Good afternoon, everyone. My name is Heather Edwards. I am the attorney for the El Dorado County SELPA and Charter SELPA. So I want to welcome you to this webinar this afternoon. We're going to be talking for probably the next 90 minutes or so about discipline for students with disabilities and some of the special rules that apply when we're dealing with disciplinary issues for students with disabilities, and really trying to balance those competing interests that we have to deal with on our campuses when you're dealing with, on the one hand, ensuring the safety and security of our campuses and maintaining the rights of all of our students and personnel to attend a school free of disruptive behavior and distractions and that sort of thing, and maintaining safe campuses, while on the other hand maintaining all of the rights and protections that students with disabilities and that their families are entitled to. So we're going to talk a little bit about that this afternoon, and some of the nuances in the laws that are designed to ensure that students with disabilities rights are protected. So if you have specific questions, just go ahead and enter them on the screen, and Drew here is with me from the SELPA, and he will be flagging me for any questions that come up, and we'll make sure that we get those read online so that you can all hear what the questions are, and then we'll make sure to respond to those. So please feel free to ask questions as we go through the presentation. So to start with, as I mentioned, there are special rules when it comes to disciplining students with disabilities. And we're going to talk a little bit about a variety of different circumstances when we're talking about students with disabilities. We're talking about students being special, potentially a student who is eligible under IDEA for special education, so they currently have an IEP. We're also talking about students who are in the process of being assessed for eligibility for special education. So though they may not have an IEP yet, if they're in the process of being assessed for special education and then a disciplinary incident arises, there are some special rules when it comes to those students as well. There's also a third category of students, which we call basis of knowledge students. So these are students who are not yet eligible for an IEP under IDEA, but if the LEA had some basis of knowledge that the student might be a special education student, then there are certain protections under IDEA that are triggered for those students as well, and we're going to talk about that as well. And finally, I know this is not a Section 504 presentation, but I can't go without mentioning, just for those folks, in case it is a surprise to anyone, that students who may not qualify under IDEA for special education yet may fall under the definition of an individual with a disability under Section 504, they are also entitled to certain protections and procedures when it comes to discipline. So again, while this isn't a 504 workshop, suffice it to say that there is a manifestation determination-like process for Section 504, pure Section 504 students, when it comes to discipline. And so just make sure that you're aware of that as well. I'll also just mention that if you're looking through your education code, unless you are like me, you probably don't flip through it as often as I do, but if you are looking in the California Education Code for anything related to discipline of students with disabilities, you'll really only find this one code section, Education Code 48915.5, which simply says we're going to refer to federal law when we're talking about suspension and expulsion of students with special needs. So you're not going to find anywhere in the Education Code all of the procedures related to manifestation determinations and that sort of thing. That's all going to be found in the federal statute and the regulations that implement IDEA, not in the Education Code. So just to back up a little bit about why are there special rules when it comes to students with disabilities. So prior to the amendments to the Education of the Handicapped Act, so that was the predecessor statute to IDEA, which was enacted in 1975, the special education needs of children with disabilities were not being met. And so what was happening were school officials were using disciplinary measures to essentially keep students with disabilities out of public education because they were more difficult to educate than non-disabled children. And so they were using the disciplinary provisions to essentially expel them and keep them out. So when IDEA's predecessor statute first came into law in 1975, one of the primary goals of this law was to eliminate excluding children with disabilities from public education, and it really was this idea of bringing them back into the public education environment. So that was why all of these disciplinary rules were put into place. Along the way, though, there has been a recognition by Congress that in certain instances, schools need some additional flexibility when we're dealing with safety issues to, again, balance that the need to make sure that we're ensuring all of the due process protections of students with disabilities and their families, but that we have to make sure that we're able to still keep our campuses safe and secure. So there has been a bit of a swing in the pendulum to give some additional flexibility to schools to be able to implement certain disciplinary procedures when really needed to balance the safety of the schools. One of the ways that Congress has tried to change this emphasis was to really have more of a proactive approach to behavior. So IDEA talks about how children with disabilities whose behavior impedes learning, either learning of themselves or learning of others in the school environment, that behavior needs to be addressed in their IEP. So it kind of, rather than having a disciplinary focus, it's more of a proactive approach to trying to address behavior in the context of the IEP before you get to that point of having to discipline a student. So along these lines of having this proactive approach to behavior, the law requires that, again, if the behavior is either impeding the student's learning or that of others, we must at least consider in the IEP the use of positive behavioral interventions and other strategies to address the behavior. And this is also an important point. Oftentimes people say, well, but the behavior isn't in any way related to the student's disability. So if you have a student, for example, who is eligible for special education under speech and language impairment or perhaps a specific learning disability, and the student is engaging in fighting behavior and that sort of conduct, other aggressive, assaultive type behavior. It doesn't really matter what category, eligibility category the student is eligible on the IEP. Once the student is eligible, then that really opens up the door to any behavior that arises now becomes the responsibility of the IEP team to be addressing that behavior if it's impeding learning, regardless of the eligibility category. So IDEA clearly establishes that IEP teams should consider and implement behavior interventions for students with behavior problems well before the point when the student exhibiting the problem behavior is facing some sort of disciplinary action. Also, that whenever a student with a disability requires a behavior intervention plan as part of the IEP, then that behavior intervention plan becomes a key element of the provision of a free appropriate public education. So that means that if a behavior intervention plan is not appropriate or is not being implemented with fidelity, that ultimately it could raise a violation of denial of FAPE by not implementing that behavior intervention plan. So what kind of behaviors should be considered and addressed by IEP teams? Just kind of as a note that dangerous behavior and non-dangerous violations of the school's disciplinary rules are not the only triggers for a behavior intervention plan. So essentially what this means is that it doesn't necessarily have to be something that rises to the level of disciplinary conduct in order to be considered behavior that interferes with the child's ability to learn. So an example of this is napping, so frequent napping during class. That's an example of a kind of behavior that you wouldn't necessarily suspend a child for napping, but it's a behavior that is impeding the child's learning. And so this was a case out of Texas that the school district was required to implement a behavior intervention plan. Another example, a 5-year-old with autism required a behavior intervention plan because she was unable to access her education due to self-stimulatory behaviors, inappropriate vocalizations, and the inability to focus. So again, those are the kinds of behaviors that IEP teams need to be looking at implementing behavior supports, even though those aren't the kind of behaviors that we think of in terms of the disciplinary context. Another type of example is this was a Ninth Circuit decision out of San Mateo where the school district was held to not be required to develop a behavior intervention plan for a student merely because the student was arrested for stealing and had a problem with truancy. So here the court felt that the truancy issue had been appropriately addressed in the IEP, but the fact that the student had been arrested for stealing, that's not the type of behavior that IEP teams need to be addressing necessarily in the context of an IEP meeting. For our charter school folks, just to be aware that the causes for discipline in charter schools could look differently than they do in traditional school districts. So as we all know, charters are exempt under the Charter Schools Act from most of the education code requirements, including all of the statutory expulsion and suspension rules. So all of the various causes for discipline, all of the procedures and timelines that are set forth in the education code that apply to traditional school districts do not just automatically apply to charters because charters are required in their charter petition to set forth how they're going to handle discipline in their schools. So they could provide for a different standard than school districts do. They can create their own procedures and timelines as long as it meets the minimum floor that of due process protection for suspending students. So, so in that, charters should really be in tune with what their charter petition actually says as far as discipline. Many charter petitions simply refer to the education code and indicate that they will follow all of the causes for discipline and all of the procedures that are set forth in the education code, but you just should be aware of what the charter actually says, and that's what we would rely on for looking for your disciplinary procedures. I mentioned due process protections for suspending a student, and the reason is that the courts have said that education is a property right that is protected by the 14th Amendment. So the 14th Amendment says that no state shall deprive anyone from life, liberty, or property without due process of law. So what this means is that the due process clause from the Constitution applies when a school wants to deprive a student from attending school for a significant amount of time because that has been determined to be a property right to be able to attend school. So we have to make sure that we are providing any student, and this applies to general education student as well, with some level of due process when it comes to depriving them from attending school for a certain period of time. So what those due process requirements are, and again this is for all students, and this is the case for all due process is some kind of notice and some opportunity to be heard. And the kind of notice that is required and the kind of hearing that someone might be entitled to in terms of due process really depends on the type of interest that is being deprived. For example, somebody who is facing the death penalty gets a whole lot of notice and a whole lot of opportunity to be heard because obviously the interest that we're dealing with is such a significant interest. So it's kind of a sliding scale when it comes to due process and what's required. So students, when they're looking to be suspended, they must at least be provided a notice of the charges, so why they are being suspended, and some opportunity to be heard. And so this came out of a United States Supreme Court case back in the 70s, Goss versus Lopez. A student who believes he was suspended without due process could bring a lawsuit and attempt to recover damages for any injury that was suffered because of the suspension if they feel that they were not provided adequate notice or not provided adequate opportunity to be heard on the charges. As just a quick note as well, there have been some recent changes in the education code. So for our school districts or for our charters whose discipline policies are in line with the education code, there was an Assembly Bill 420 which took effect in January, which did make some changes to the statutory causes for discipline, specifically Subdivision K of Education Code 48900. And what the change was is that students in grades K through 12 can no longer be expelled solely on the basis of willful defiance or disruption of school activities, and also that school administrators are prohibited from suspending students for grades kindergarten through 3rd grade for willful defiance or disruption of school activities. So I just wanted to make a note of those changes because really of the shift in policy to focus more on positive behavioral strategies rather than suspending for these particular causes. So for special education students, what is considered a removal from the environment that potentially could trigger the protections under IDEA? So a removal is any time a child is removed from his or her educational placement for disciplinary purposes, such as a suspension or an expulsion. So the U.S. Department of Education has said special education students are removed when they cannot progress in the regular education curriculum, when they cannot receive services or continue to make progress on the goals listed in their IEP, or they're unable to participate with their non-disabled peers to the extent dictated by their IEP. So we get the question quite frequently about, well, what about in-school suspensions? Is that considered a removal? Because the student is still in school, presumably they would still be able to progress in the regular education curriculum. They may still continue to receive services at school. But the question is how you implement the in-school suspension. So for example, if the in-school suspension is happening in the principal's office, the concern is that last bullet there about whether or not they're still participating with their non-disabled peers to the extent dictated by their IEP. That was the question? Okay, so there was a question about that. So that is the concern with in-school suspensions, is if they're sitting in a room by themselves, even if the special education service providers are coming to them in the room and providing those services, if they're not interacting with their non-disabled peers, so for example, if their IEP says 75% of the time they should be interacting with their non-disabled peers, then this is going to be considered a removal, even though it's an in-school suspension. So what that means is it's not that you can't implement in-school suspensions for students with disabilities. You absolutely can if that's an appropriate intervention for your school. But you need to make sure that you're counting it as a removal when we start talking about counting the days that a student has been removed from their educational program. In-school suspensions would most likely count as a removal. Also, we get the question a lot about what about bus suspensions. So if a student has engaged in inappropriate conduct on the bus, there may be, in terms of a disciplinary action, that the student is suspended from being able to ride on the bus for, a period of time. And so if transportation is included on the student's IEP as a related service, then a bus suspension is going to be treated like any other suspension unless some sort of alternative transportation is provided. So if you are offering a school bus on the IEP to be providing transportation, and if it's a required service on the IEP, you can't just not provide the student transportation if you are trying to impose a bus suspension. You would be required to find alternative transportation in the event that there is some sort of bus suspension. So that could be, some other sort of transportation service that you contract with. It also could be that you offer to reimburse the parent if they're willing and voluntarily agree to provide the student with transportation. You could provide reimbursement to the parent if they were willing and able to transport the child. And that would qualify as you meeting the terms of the IEP and providing transportation. So just a few pitfalls when we're talking about suspending students with disabilities. Of course, we want to make sure that we're properly investigating incidents and that we provide an opportunity for those involved, including students, to provide written statements related to what they saw, what has occurred, because that will become very important down the road if and when the student and their parents request some sort of a hearing related to the disciplinary issue. So if we have those written statements of the students involved, of the staff involved, that can be very helpful. But we do have on occasion concerns about perhaps administrators kind of coercing students into, filling out statements and that sort of thing. Obviously, we can't force a student to write a statement, but that certainly would be a good practice, is at least provide them the opportunity to do so, and that would be very helpful in documenting your investigation. For students with IEPs, we certainly want to make sure that we're implementing any behavior interventions that are included in the student's IEP prior to the offense, because that will present challenges later on down the road if you haven't been implementing the IEP and whatever behavior supports are in place. That could cause a problem later on down the road, as we'll talk about with manifestation determinations. Of course, we want to make sure that the length of the suspension is equal to that of non-disabled students. So that is just, we want to make sure that we aren't treating disabled students any differently than we would our non-disabled students when we're imposing suspensions and expulsions. We also want to make sure that we're following our policies and that we provide timely notice to students and parents of the child's suspensions. One of the pitfalls that we see schools engage in is, for example, well, we didn't suspend the student for the behavior, we just asked the parent to come pick them up and take them home for the day because we were having a hard time with little Sarah's behavior in the classroom. The concern there, again, you're essentially removing the child without providing all of the due process that really families are entitled to. So just because you might not call it a suspension, if it is a suspension and it is a removal, then we want to make sure that we're properly documenting that and providing notice to the parents of what's going on. And so we want to be very cautious about that. And then very important to keep close track of the number of days of suspension, and we'll talk about why that is in a minute in terms of the 10-day rule. That also means for partial day suspensions, we get the question a lot about, well, what if I only suspended a student for a few periods of the day and not a whole day? Should we count that as a whole day, or do we count up the various pieces of the day that were suspended, that the student was suspended? I think best practice is to round up, if you will. So if you suspended a child for one period, I think you would certainly count that as at least a half day, a partial day suspension. And in the interest of caution, I would always round up and count it as a full day. I've heard from folks that even the Department of Education and with CalPADS reporting, I think that they would require it to be counted as a full day suspension, even if it was only a portion of the day. The other thing to be thinking about are your transfer students. So if you have a student who has transferred into your agency, whether it's a charter school or a school district, in the middle of the school year, we need to make sure that we get those disciplinary records transferred from the previous school district or the previous LEA, so that, because it's counting time calendar days in a school year. So we want to make sure that we have some idea of how many days has this student already been suspended before they came to us, and we have to count those when we start counting days. We don't really get to start the clock all over again once the student comes to us, even in the middle of the school year. So making sure we get those records, particularly the disciplinary records, so we're keeping track of those amounts of suspensions. And then also, we don't want to rely on suspensions necessarily to modify behavior. As we already talked about, making sure that the behavior is being addressed early and often in the IEP itself, and not just using suspensions in hopes that that will somehow be an effective intervention for a student with disabilities. The other thing we get questions about on occasion is about involving law enforcement. Oftentimes there may be an incident that happens at school that rises to the level of needing to involve law enforcement because we just have so much concern about the safety and security of the child or of the school. So in IDEA, there is a specific regulation that says that there's nothing in IDEA that prohibits an agency from reporting a crime committed by a child with a disability to appropriate authorities, or prevents law enforcement from exercising their responsibilities with regard to crime. So certainly, if we have some concern, you're not in any way violating the child's rights by getting law enforcement involved. However, with that said, oftentimes schools that involve law enforcement with students with disabilities, there is sort of this proportional effect that it may increase your chances of litigation. Oftentimes, as soon as the law enforcement gets involved, we may have parents alleging that the school didn't implement the behavior intervention properly, and that's what caused the misconduct. We may also hear parents alleging that that the reason that you contacted law enforcement was somehow in retaliation for the parent or the student advocating for their disability-related rights. So we certainly see kind of an uptick when law enforcement has gotten involved. Not to say that that wouldn't be appropriate in many circumstances, but that we do want to be aware that that can sometimes increase the litigious nature of the situation. So we don't want to necessarily skip implementation of the behavior intervention plan to call law enforcement. So again, if there is a behavior intervention plan in place and there, for example, are aggressive behaviors and there's a certain strategy that the IEP team has determined that should be followed to try to address those aggressive behaviors, we want to make sure that our staff are following that plan as opposed to jumping right to making a phone call to law enforcement. We really want to make sure that that behavior intervention plan is being put into place first. But of course, involve law enforcement when the student is posing a clear danger to him or herself or to others, when there's been drugs, weapons, or any sort of serious threat. Of course, we would want to involve law enforcement when we're dealing with those sorts of issues on our campuses. And also, I think it's important to regularly meet with law enforcement who work with the school so that they're aware of the issues that you're dealing with, and so you can have some good collaboration with your law enforcement. So when there are issues that arise, you all have a good sense of how to respond appropriately. So you have a student who's eligible for special education, and they've committed some sort of act that constitutes grounds for suspension or expulsion. So what do we do now? And there are certain protections, as we've talked about, that are going to be triggered when you've removed a student with disabilities, and that has created a change in placement. So we first have to determine, has there been a change in placement? So if a removal is, say, a one-day suspension, a change in placement occurs in the disciplinary context when either the removal has been for more than 10 consecutive school days, which doesn't happen very often. Most schools abide by, you wouldn't really suspend more than 5 school days in a row unless you're looking at expulsion. However, this second one here, though, if a child has been subjected to a series of removals that constitute a pattern, because the series of removals totals more than 10 school days in a school year, and the child's behavior is substantially similar to the child's behavior in previous incidences, and because of any other additional factors. So what this means is if you have totaled in a school year more than 10 school days of removal, that is going to be considered a change in placement that is going to trigger your obligation to conduct a manifestation determination meeting. We've seen folks try to argue, for example, where there have been instances of suspension that are more than 10 school days, and they try to argue that the behavior was different enough that it's not a pattern of behavior. Because it is required to be substantially similar to the previous behavior. The problem with that is you could probably relate various behaviors from a cell phone infraction to fighting. There are certainly arguments that can be made that while they might seem very different, it's a similar kind of behavior because they're both maybe defiant type of activity. So more often than not, it's pretty easy to say that behavior is going to be similar to previous behaviors in most instances. So that's why really the rule of thumb really is about counting those days in the school year, and then once we get to that 10 school days, that's when the manifestation determination requirement is going to be triggered. So that doesn't mean, and I think this is really important, that doesn't mean that we can never discipline a student with disabilities. So I like to think of it as for up to 10 school days, we kind of have what we call the fake-free zone. So you can treat, for up to 10 school days, you can treat students with disabilities as any other student. And you can remove them from school for up to 10 school days regardless of their disability. Even if it is a student that it's crystal clear in your mind that this is related to the student's disability, you can treat them as you would any other student for up to 10 school days. It's not until after that 10th school day that then the student must continue to receive educational services to allow them to participate in the general education curriculum, even if it's in another setting, and to continue to make progress toward meeting their goals. So really after that 10th day, we have to make sure that that child is receiving FAPE, even if it ultimately ends up being in another setting. So let's talk a little bit about manifestation determinations. This is an area where I've been involved in a number of hearings with regard to the process and procedures around conducting defensible manifestation determinations. And so we're going to spend a little bit of time talking about some of the pitfalls and the things to be aware of when we're talking about manifestation determination meetings. So the basics really are that within 10 school days of removing a student beyond that 10th day, so we've hit our 10-day mark of the student having been disciplined and removed from school. the school district or the charter LEA, the parents, and relevant members of the IEP team are required to meet to answer 2 questions. The first one is whether the conduct was caused by or had a direct and substantial relationship to the student's disability, or was the conduct the direct result of the school's failure to implement the student's IEP. So the whole purpose of this meeting of the school, the parents, and the relevant members of the IEP team is really to answer those 2 questions, which seems easy enough, but as always, the devil's in the details. So first of all, we want to make sure that parents are provided reasonable notice of these manifestation determination review meetings because of the significant implications of these meetings, because certainly the outcome of this meeting could mean whether or not a school can move forward with an expulsion or not. We have to make sure that we are notifying parents with adequate time so that they are able to participate in these meetings. And these timelines can come up very quickly. That is one of the challenges with manifestation determination meetings, is that once you're getting really close to that 10th school day, that you have to get that meeting scheduled within 10 school days, or else the student will be coming back to school. They can't continue to stay out of school beyond that 10th day. So you really have to get them back into the school environment and schedule those meetings quickly. So all of the IEP meeting notice requirements aren't expressly applicable to the manifestation determination review meetings, but they do provide guidance in evaluating the reasonableness of providing notice of these meetings. So the notice must support meaningful parental participation in the process. So again, we want to make sure that they have adequate notice of the disciplinary incident itself prior to the manifestation meeting, and that they have adequate time to prepare. So we really want to make sure that they really understand what the purpose of this meeting is, what was the disciplinary incident that led to the reason to have this meeting, and so that they have enough information to know the significance of what this meeting is about. Looks like we have a question.
What was the second question that must be asked during the manifestation determination meeting?
The second question is whether the conduct was directly caused by the failure of the school to implement the IEP. So if, for example, the student had a behavior intervention plan, and it could be any service, quite frankly, maybe it's counseling service, but if there's any service in the IEP plan or in the IEP itself that was not provided for whatever reason, and the manifestation determination team determines that the reason that the disciplinary incident happened, whatever the conduct was because we hadn't provided that that service or some other portion of the IEP, then that is the second question we have to be answering, and we'll talk about what that means in a minute. So what happens if you miss that 10-day timeline? As I mentioned, sometimes that 10-day timeline for scheduling a manifestation meeting comes up rather quickly, and you're trying to get all the players in place. So while we try our darndest to make sure we don't miss timelines, if you do, there are cases to support that it's not going to necessarily be a violation if you've considered some remedial measures. So an example. There was a student who was suspended, and the manifestation determination meeting didn't happen until the 14th day of suspension. So we missed our 10-day timeline. So here, even though it was a technical violation, the student didn't suffer any educational harm because the LEA allowed the student to make up all of the work that he had missed with IEP services, and they actually removed the suspension from the student's records. So think about, if you do miss a timeline, are there ways that we could make up for it that later on down the road, if there is some sort of a procedural violation that's alleged, if we can say that we remedied that by something similar to what happened in this case. The other thing that's very important is to make sure that when we're describing the conduct that occurred, to the team, to the manifestation determination review team, that we have a very accurate description of what happened. So it's really, really important. The details matter. As someone who's been involved in a number of manifestation determination due process hearings, which have lasted 4 or 5 days, let me tell you that the details matter about what actually happened, and it can turn on one simple fact of what actually occurred. So we need to make sure that the team's not mischaracterizing the student's conduct in any way, and that whatever behavior is described to the team is what actually occurred. So, for example, this was a case where the district was found to have violated IDEA when it assumed a middle schooler with an emotional disturbance intended to distribute controlled substances on school grounds. And here was the problem. What actually happened was the student had passed a note to another student that said, "I have pills," and named what those 2 pills were. When the student was searched, the principal actually didn't find any drugs on the student. When they got to the manifestation determination meeting, what was described to the team as what happened was student wrote a note that stating or intending to initiate the sale or transfer of drugs. So based on this information, the team assumed that the student actually had pills in her possession and that she had intended to distribute it. But so they weren't really given the whole picture of what actually happened, that the principal actually didn't find any drugs on the student when the student was searched. So even that small detail makes a difference, because you have to make sure you're really providing the whole picture to the team about what occurred. So this really gets down to also making sure you've got the right people at the manifestation determination meeting in order to give an accurate description of the student's actual conduct. So we are required by law to have someone from the district, the parent, and relevant members of the IEP team. So it's really up to the school and the parent to decide, well, who are those relevant members of the IEP team that need to be there to help us answer these 2 questions. So first of all, we will want to make sure that we're including someone who has specific information about the incident. So that doesn't necessarily mean that you have to have an eyewitness of whatever the incident may have been, but you better have somebody there who can really give an accurate description of what occurred. It may be that it's an eyewitness, but if whoever is leading the meeting is just reading off of a form and doesn't really have additional information about what actually happened, that could be problematic for you. So make sure you're thinking about who can be there to really describe what occurred. Another good strategy is to ask what the student or the parent's version of the conduct was, because as we know, they may have a very different version of what actually occurred, and I think it's important for the team to hear that the version of the incident may be different, and I think that would be important information for the team to consider. And also to make sure that we are putting the behavior in context. So what was happening right before the conduct? What happened right after? Those are the kinds of considerations that the team should be thinking about. For example, when we're talking about impulsive behavior, we may need to be looking at right before the incident happened in order for us to determine whether that was impulsive and related to a student's disability. We need to know about what happened in the morning before the incident happened and what maybe happened right after. So really try to make sure you're putting that behavior in some sort of context. There is some guidance that we have received from the Special Education Office out of the U.S. Department of Education that talked about how hearing officers are permitted, but I'm going to take a pause real quick. I think we have a question on the last slide.
Should the MD form be filled out at the meeting with everyone's input, or should it be completed prior to the meeting?
That's a great question. I think as with even with IEPs, As long as it's a draft document and describing the conduct that has occurred, I think that that could certainly be something that you fill out ahead of time. But beyond that, I wouldn't suggest filling out much more in terms of answering the two questions. And I certainly would want to take into account and revise the document as we get the parents' input about the actual description of the conduct. So if the conduct is worded in such a way and the parents disagree with the actual version of the events, I would want to note that on the form, and I'd want to really make sure that we are capturing in the manifestation determination document all of the parent input, and we'll talk about in a minute why that becomes so critically important in terms of considering the parents' input. So, so back to this OSEP guidance. What they had indicated back in 2012 was that hearing officers are permitted but not required to determine whether the student's conduct actually violated the school rules. So the problem here is that you're essentially, so if schools are going to do some sort of an expulsion hearing, that's typically where the school board is looking at whether or not the student actually committed some sort of an offense that is an expellable offense. But what OSEP has said is that in order to determine whether or not a student with disabilities rights have been violated and whether or not the manifestation determination team got it right, they might have to look at whether or not they actually violated the school rules. So it's kind of a second bite at the apple. And so it has caused some concern amongst school attorneys that it could provide additional opportunities for students to argue their innocence and overruling administrators' decisions because essentially you're doing an expulsion hearing within a special education hearing. And there was concern about it increasing the length and cost of due process hearings. So as I mentioned, I certainly have seen the length and the time going into due process hearings over these manifestation hearings can be pretty intense and could be certainly cost prohibitive. So it's just kind of an interesting note that hearing officers are essentially looking at doing expulsion hearings as well as looking at the disability issues. So again, back to we want to make sure that we have the right people there. Who will be there to explain how the student's IEP was implemented? So since we have to answer that second question about was the conduct directly or substantially related to the failure of the school's implementation of the IEP, we need to make sure that we have somebody there at these meetings to talk about was the student's IEP actually implemented and how was it implemented. So if there are specialized academic instruction services in the IEP, we got to make sure we've got somebody there who can talk about whether or not that's been provided or whether or not the behavior intervention plan has been implemented with fidelity. So we want to make sure we've got somebody that can talk about that. We also want to make sure we've got somebody there who can explain how the student's disability manifests itself at school. So this may be your school psychologist, it may be a teacher, but in order for us to answer those questions and to answer particularly the first question about whether or not the conduct was related to the disability, we need to know what this student's disability looks like in the school environment and how it manifests itself at school. So while we may have a student with ADHD diagnosis, for example, what does that look like in the classroom? And because not every disability is the same, and so we need to have people who have direct knowledge about that student to be able to share that information with the team. And then who will be there to be able to explain the various characteristics of disabilities? So we need to have somebody there who can say, well, generally, you know, students with disabilities, with this sort of disability, whether or not it is typical for the student to engage in that sort of behavior. So you're going to need to have somebody knowledgeable about the particular disabilities who can discuss that. So one of the keys for manifestation determinations, and this is true even for IEP meetings, is that the team has to consider all relevant information in the student's file, including the child's IEP, teacher observations, and any relevant information provided by the parents. So that doesn't mean we necessarily have to agree with everything, but there is this requirement to consider it as a team. And if we look at the dictionary definition of consider, that means that we have to think carefully about something in order to make a decision. And we have to make sure we're documenting the team's consideration of all of those various elements, the information in the student's file, teacher observations, and relevant information provided by the parents, documenting that we've at least considered these types of issues. We also want to make sure that we don't pick and choose which details of the incident and the student's history to consider. So it really should be a full picture. Again, not only the incident, but also the student's file and what the student's history looks like, and to be able to consider all relevant information. So a case example here, we have a 13-year-old student who is eligible under the category of emotional disturbance. A therapist had diagnosed the student with PTSD, post-traumatic stress disorder, arising from his brother's suicide. However, the diagnosis was not available at the time of the misconduct, but this diagnosis was available to the team at the time of the manifestation determination review. The student was invited by friends to participate in the vandalism of the principal's home on the anniversary of his brother's suicide. The IEP team concluded that the misconduct was not a manifestation of the child's disability because it differed from that which the student had displayed at school. Typically, the student at school would take on leadership roles and would seek attention and display defiance, but they didn't feel that vandalism was the type of behavior that they had seen historically with this child. Here, the administrative law judge determined that the IEP team failed to consider all relevant information in the student's file. So specifically, that the team overlooked a recent behavioral evaluation that noted teachers' concerns with students' leadership functioning, that they failed to discuss prior arrests for out-of-school conduct, that they failed to consider that the conduct would have brought the student his friend's attention, and that he didn't act as a follower when he alone painted an obscene image, and that the team gave insufficient weight to the therapist's testimony directly linking the act to the recurrence of the trauma. So if there's information that's being brought forth and information in the student's file related to prior arrests, related to previous behavioral issues, teacher concerns, all of that information really needs to be put on the table to at least consider. Doesn't mean that it's going to be determinative, but at least consider it and document that you've considered it at the manifestation determination meeting. So as I mentioned, it's so critical to document how your decisions were made. So what IEP was reviewed? So when you're answering that second question about whether or not the conduct was directly the result of a failure to implement an IEP, we better make sure we're all talking about the same IEP document. So we want to be very clear in the manifestation paperwork, what IEP was it that we were all looking at to make sure that, is this the one we're talking about? This is the one that the parent consented to. This is the one that should have been being implemented, and document that in your manifestation paperwork. Also document what assessments and reports were reviewed. So if there were a review of the psychoeducational assessment, or if the parent brought some sort of information from a physician or from some sort of independent therapist, document in that paperwork about what specifically was reviewed. What questions were asked by various team members and how were the questions answered? How did the team make the connections between all of the information that was provided and the conclusions that were reached by the team. So when you're looking at that information in a student's file, because certainly that's one of the things that we're required to look at, how far back should you look? Generally, we recommend that you look at any assessments that are current, but are within that 3-year reevaluation cycle. But again, it's one of those it depends sort of answers. So older information that goes beyond the 3-year assessment cycle might be important. So if you're trying to determine whether or not there's some sort of pattern of behavior, that may be important to go back even further in the file to see what you see even beyond that. So for example, if the student has been fighting in kindergarten and then elementary, then middle, and then high school, the more long-term a pattern of behavior, the more likely that that behavior is going to be related to the child's disability. So it certainly could be that we need to go back a little further beyond just 3 years. The other thing is to consider potential disabilities. And we learned this a hard way in a case that I was involved in, where the district has no knowledge of certain disabilities, but the information is brought forth at the time of the manifestation meeting. So, for example, if we didn't have information about a certain diagnosis at the time of the conduct, but then at the manifestation meeting, surprise, the student has a new diagnosis, again, that has to be something that is at least considered by the IEP team, and it really doesn't matter what was known at the time of the incident or at the time of the prior IEP meeting. It's supposed to be what is considered at that meeting at the time. Another pitfall is to make sure that you're not limiting consideration of disabilities only to eligibility categories. So, for example, you may have a student who has a deaf and hard of hearing eligibility category, but perhaps there is evidence in the record that the student has a history of depression or a history of anxiety. So you don't need to just, and you shouldn't just focus your consideration of, well, did the student's disability category of deaf and hard of hearing cause the conduct, and not consider all other disabilities within the student's file. So again, we should be looking at that depression and looking at anxiety and determining whether or not that's a potential reason for the conduct. And this one, I think, is, I can't underscore this one enough, that teams kind of fall into that trap of focusing the disability just on what the student's eligibility category is and not looking at other information related to potential disabilities. So what happens if you're at an IEP or at a manifestation meeting and the parent surprises you with some sort of a new diagnosis? So what the law has talked about is that there aren't really do-overs. So once you have made a determination as the manifestation determination team, IDEA doesn't provide for a reopening of that manifestation meeting where maybe later assessments determine that the child has some additional disability related to the behavior. So you wouldn't go back and do it over again. And you wouldn't want to reconvene a manifestation once you've already made that decision and then new information is discovered about a new disability. You don't go back. However, if you're at a manifestation determination meeting, it could be that the team says, hey, we don't feel like we have enough information in order to answer these questions. So the team could determine that additional evaluations need to be completed in order to answer those 2 questions. So the process there would really be, you need to convene that manifestation meeting within the 10-day timeline, but then the team can decide to continue the review at a later time in order to consider the results of the completed evaluations. So you may need to conduct some additional assessments, get that information, and bring that to the team in order to answer those questions. We want to make sure that we're, again, considering parents' reports of behavior outside of school. So just like in the case example we talked about earlier, if parents are reporting out-of-school arrests, that's certainly something that should be considered by the manifestation determination team. So another example, parents report that a student who hit another student has a history of hitting other kids in the neighborhood. While you might have no evidence of any sort of aggressive behavior in the school setting, our job would be to document that the team at least considered the parental input. Most likely, all of the school observations about the student's aggressive behavior and any data that we have, that's certainly going to weigh more heavily than the parents' anecdotal reports of behavior outside the school setting. But again, our job is to consider the parents' reports and consider any relevant information that the parent brings forward. So that's the key. The other thing to be aware of is that the conduct, in order for that first question, the conduct has to actually be caused by or have a direct and substantial relationship to the disability. So what does that mean? It really means that the disability has to significantly impair the child's behavioral controls. So if the conduct is only just a little bit related to the child's behavior, that's not enough. It has to be a direct and substantial connection between the disability and the behavior. So an example, and this is a Ninth Circuit case that we use often when we're looking at this attenuated relationship as not being enough. An example is where a child's physical disability results in his loss of self-esteem, and the child consciously misbehaves in order to gain attention or win approval from peers. This scenario is no less common among children suffering from low self-esteem who do not have a disability. So it couldn't be argued that because a student perhaps is in a wheelchair or has some other disability, and so that they're acting out because of those issues. That is not going to be a sufficient connection. It has to be a substantial connection between the actual disability and the conduct. I think we have one more question.
Should the information that is discussed and considered during the meeting be included with the MD form or separate meeting notes page?
I think a separate meeting notes page. So I wouldn't suggest if you have documentation, for example, if you've reviewed the psychoeducational assessment and information that the parent provided to the team, I think it should just be documented in the notes, documenting your process, and not necessarily attach all that paperwork. All of that paperwork is going to be included in the student's file anyways, and it shouldn't necessarily be attached. I think just to document what it was that you actually considered is sufficient. Good question, though. And of course, when we're conducting manifestation determinations, we want to make sure that we're handling them on a case-by-case basis. Schools may consider unique circumstances for students with disabilities who violate school rules. So what was a manifestation of a disability for one student might not necessarily be a manifestation for another student. It's going to be so fact-specific in every circumstance. So that's why we really want to be cautious to not make any broad generalizations about particular types of disabilities causing particular types of conduct. So for example, you don't want to necessarily assume anything when it comes to conducting manifestations. So for example, there's no need to have a manifestation determination because everybody knows that anything an emotionally disturbed student does is a manifestation of his or her disability. Obviously, that's not true. And so we want to make sure that we go through that process and we document the process. We look at the conduct. We look at the child's specific disability and figure out whether or not there's a connection there. You also want to make sure that you resist making assumptions about a student who uses drugs. Oftentimes there's arguments made where a student is disciplined for some drug-related issue, and there may be some argument that the student was self-medicating. because of their disability. That may be the case, but it may only be an attenuated relationship, which, remember what we talked about earlier, that that's not enough. It has to be a direct and substantial relationship to the disability. So one of the areas that we see come up a lot is whether or not a student with a particular disability, for example, ADHD, whether the conduct was impulsive. And so we see impulsivity come up a lot in manifestation determination cases. So I thought it would be important to just chat about that a little bit because I hear often from our schools that we work with that pretty much any conduct of a student with ADHD could be argued that it's impulsive. And so how do we look at that, and what are some of the factors in deciding whether or not something was impulsive and related to a student's disability? So some of the factors that the hearing officers look at is the proximity in time, from the time that the student decided to act and the behavior. So if we're lucky, maybe a long period of time went by, which is going to certainly be less likely to argue in favor of it being impulsive. But even if the behavior unfolds rather quickly, if there were opportunities for the student to stop what he or she was doing and there was some sort of a progression of events, that's going to be less likely that it's going to be considered impulsive. If there's any sort of factors showing some sort of intent or planning, even if it's a series of quick decisions, that's going to weigh against it being impulsive. Also, maybe there were other factors that contributed to the behavior. So if there was some sort of heightened emotionality, the student was very angry about something, that's going to, again, weigh in favor of it not being an impulsive act. Or potentially just the developmental stage that the student is in. So while certainly one could argue that certain behavior is impulsive, on the other hand, you could argue that this is very common in students of this age to act in this sort of manner, and that it's not something that is directly correlated with the student's disability and impulsivity. So a couple of hearing officer decisions that talk about this relationship between the disability and behavior, specifically as it relates to ADHD and impulsivity. This was a case that I was involved in where the student's conduct was found to not be impulsive. The student was eligible for special education with a under deaf and hard of hearing, but also that there was information in the record that the student had an ADHD diagnosis. So what happened here was the student was very angry and upset over discovering information that had threatened his relationship with his girlfriend. So they were at school, and the student, and this is a high school age student, the student wanted to confront the girlfriend at school, and the school officials were trying to intervene and not allow the student to call the girlfriend out of class and interrupt school. Multiple times the school officials had told the student to stop, you can't talk to the girl right now, leave her alone, go back to class. Multiple times had told them to stop. In an effort to try to get the student away from the girlfriend, they tried to get the girlfriend into the office and away from the young man. The student continued to pursue the girlfriend, and the assistant principal stood in the doorway of the office with his arms kind of in the doorway to block access and kind of block the young man from his girlfriend. And unfortunately, the student punched the assistant principal. And the student remained very angry for a prolonged period of time afterwards. So in this case, the student's attorney was arguing that at that moment that the student punched the assistant principal, that was related to ADHD and that this was impulsive conduct. But the hearing officer here said no, that it was not. Do we have another slide coming? No, we don't. So the hearing officer here had said that this was not impulsive conduct because there had been multiple opportunities for the student to stop what he was doing, that really it was because the student was upset over the issue with the girlfriend, and that this was not an impulsive act. So this is one of those situations where the student's attorney tried to argue that the event that we're talking about was that split second where the student decided to punch the assistant principal. But we felt like it was very important to paint a complete picture of what had happened leading up to the punch. You know, the multiple directives from school officials to tell him to stop. They were following him up to the office and telling him to stop. He continued to be angry and upset and crying after this all occurred. So again, all of those factors make it seem like a much more longer, drawn-out ordeal where there were multiple options for the student to take a different course rather than to punch the assistant principal. So we were successful in this case of proving that it was not impulsive. Unfortunately, though, this was a case, back to our procedural issues and making sure we consider all relevant information. At the manifestation determination meeting in this case, the parent presented information that the student had been diagnosed with bipolar disorder. And unfortunately, the team, while they looked at the hearing impairment and they considered the ADHD diagnosis, they didn't really consider the information that the parent had presented about the bipolar diagnosis. And as a result, even though the conduct was not found impulsive, because of the procedural issue, the hearing officer ordered the school that if they wanted to move forward with expulsion of this student, they were going to have to go back, redo the manifestation determination meeting, and consider that bipolar disorder diagnosis, even though that was completely new information to the team. But the fact that the parent brought it up, it needed to at least be considered at that time. So as a result, this kiddo came back to school. This was another fun one that I was involved in a few years ago, where, again, the student's conduct was not determined to be impulsive. It was a high school-aged girl with ADHD. She had accepted marijuana as a present for her birthday and planned to smoke it with a friend the following morning. Once in the school bathroom the next day, she texted a third pupil to bring a lighter to the bathroom, and the 3 students allegedly smoked the drug. The parent challenged the manifestation determination review team's conclusion. They concluded that it was not a conduct that was directly related to her disability. She argued that the student's decision was triggered by her impulsivity, and that she also was afraid to not accept the marijuana because the person who gave the marijuana to her was a bully. Interestingly, too, the parent also argued that when the young ladies went to the bathroom that they didn't have anything to smoke the marijuana with, so we understood that they rolled it up in some binder paper, and that she had to have a student bring a lighter to the bathroom. So those were some of the arguments that the parent tried to raise and to try to show how, well, she didn't plan for this because she didn't bring anything like a lighter or any other, paraphernalia with her. So this wasn't an impulsive act. But as you can see, there were lots of opportunities for decisions to be made which weighed against this being an impulsive act. Here in this case, the hearing officer noted that also that the ADHD symptoms primarily manifested at school as a lack of sustained attention and organization, that while the parent was arguing impulsivity, that really the student's ADHD didn't manifest itself in an impulsive way at school. That there was testimony to show that she had engaged in a little bit of speaking out of turn, but that she really did not have impulsive tendencies at school. So at best, what the hearing officer said was that the student's initial decision to accept the marijuana may have been impulsive, and that the impulsiveness may have had an attenuated relationship to her disability, but her involvement in planning the incident and participating in it, even though she had a night to reflect, demonstrated that her actions were deliberate and not impulsive. On the other end of the spectrum, this is a case where the student's conduct was found to be impulsive. The student had ADHD and was also a specific learning disability category. The student's ADHD did cause him to be impulsive and to act without thinking, and was being controlled by medication. So a couple of weeks before the incident, the student had actually stopped taking the ADHD medication and didn't tell anybody. So here the hearing officer said that it was an impulsive act when this student acted as the middleman when he helped student A buy marijuana seeds. So what happened was this student was approached by student A. Student A said, "Hey, where's student B? I want to buy some marijuana seeds." And this student impulsively took him to student B rather than just pointing out student B. So as a result, students' involvement in this marijuana seeds transaction was a single incident of less than 5 minutes. The judge said that this was an impulsive act. Student wasn't thinking about the consequences and getting involved in some sort of a drug transaction. And so this was impulsive and should have been determined to be a manifestation of the student's disability. Another example, we had a student with a specific learning disability and ADHD. Student's IEP addressed only the specific learning disability, and the district learned for the first time during the manifestation meeting about the student's ADHD diagnosis. So the conduct here was the student had given the classmate 2 prescription sleep aids by placing the pills on her textbook in the classroom. The exchange occurred after the classmate spent about 2 weeks begging the student to share her medication with her. And the night before, the two had exchanged text messages confirming their plan. And then both the students took pills during class. Because of the student's conduct following 2 weeks of discussing it with the classmate and a text message the night before, the hearing officer said that these actions were not the result of impulsivity brought on by ADHD. So if we get through the 2 questions that we need to answer, and the team answers yes to either of the 2 questions, so yes, the conduct was directly and substantially related to the disability, or yes, the conduct was the direct result of the team's failure to implement the IEP. If you say yes to either one of those questions, the student must be returned to the placement from which the student was removed. And this is unless the parents and the school decide in the context of an IEP meeting to change the student's placement. But if we don't have agreement between the school and the parent to change the student's placement, if it is a manifestation of the disability or if it's a failure to implement the IEP, the student needs to go right back to the placement from which they came. So in other words, you can't expel a student with a disability or otherwise change his or her placement if the team answers yes to either of those questions. If the team answers no to both of the questions, then the student may be disciplined in the same manner as students without disabilities. So the student's conduct, if it was not caused by the disability or was not the direct result, then you can move forward with expulsion and treat them as you would any other student. The recourse for parents, if they disagree with this determination, is that parents have a right to file a request for due process challenging the team's manifestation determination. And that typically would be an expedited hearing, which is a much faster track due process hearing than a typical due process hearing over the appropriateness of an IEP. If there's no consensus, you know, parents are equal participants in the process. They don't have veto power. So if you can't reach consensus, ultimately the LEA has to make the decision and then provide prior written notice of what the agency's decision is. And in these situations, be prepared for the manifestation determination meeting to conclude without consensus. The parent may disagree. And on most forms, there is a portion of the form where their parents can indicate their disagreement with the ultimate decision. So as I mentioned, the student would go back to their placement that is called for in their IEP unless the school and the parent agree that, you know, we are seeing some behaviors. We believe that we need to look at a different placement. Absolutely, the IEP team can be looking at making a change in placement if we think that that is appropriate and necessary. But that would require parental consent. in order to do that. There are a few exceptions. Again, as we talked about at the beginning, Congress and their recognition of certain circumstances where schools need to have some flexibility in being able to discipline students. So we have 3 special circumstances when a school may remove a student to an interim alternative setting for up to 45 school days, even if it's a manifestation of the child's disability. So, and the 3 circumstances are drugs, weapons, or serious bodily injury. So if you have any one of those 3 types of issues that you're dealing with, you still need to go through the manifestation determination process, but ultimately, even if you answer yes, you can still move the child for 45 school days to an interim alternative setting, even if the parent does not consent to that. Briefly, I just wanted to mention that one of those special circumstances, the serious bodily injury circumstance, is an extraordinarily high standard in order to meet the serious bodily injury standard. It certainly would require more than minor medical treatment from a school nurse. So the legal definition of serious bodily injury is substantial risk of death, extreme physical pain, disfigurement, some sort of loss or impairment of function of a bodily member, organ, or mental faculty. So it really, really is quite severe in order for this serious bodily injury to kick in. I have a few examples listed here that shockingly hearing officers determined that even a broken nose didn't fit within the narrow definition of a serious bodily injury. A broken nose is not serious enough. There's some other examples here, as you'll see, where it's not rising to the level of serious bodily injury. This case here from Tehachapi School District, the hearing officer again said it wasn't serious bodily injury when the student gave a mild concussion to one student and broke the nose of another. Again, that's not going to be enough. So if you are faced with the potential issue where you want to be able to use that serious bodily exception in order to remove a child for 45 school days, here are some factors to take a look at. You know, is the injury not necessarily life-threatening, but more than slight? Was there some sort of medical treatment required? What was the level of pain suffered by the person? Was there some sort of ongoing pain management required? How quickly did the person come back to school, or if it was a staff member that was injured, how quickly did the person come back to work? So it's just a variety of factors to consider to really assess whether it would meet that high standard of serious bodily injury. And of course, there's even more exceptions that even if the team answers yes to the manifestation question, so they do believe that the conduct was related to the disability, if a school believes that maintaining the current placement of the child is substantially likely to result in injury, either to the child or to others, schools may file for a due process hearing, and it would be an expedited hearing, so again a much quicker timeline for getting a decision, seeking an order from a hearing officer to change the student's placement. So what does all that mean? If you have a child who is continuously trying to disrupting the environment and over and over and over again, you are seeing behaviors and you're very concerned that continuing this placement and that the child may need a much more restrictive placement could injure somebody. And perhaps you have offered a more restrictive placement. Perhaps you've offered a non-public school for the child and the parents aren't willing to agree to that change. In order to make that change over the parent's objection, you could file what's called an expedited hearing to seek an order to change that student's placement for 45 school days. So again, this was the recognition of Congress to give us some tools, but it would require filing a due process hearing and getting a judge to order that. So who determines what that interim alternative educational setting is? So once you've determined that the student should be removed to an interim alternative educational setting either for 45 school days for those special circumstances, or because you've decided that it's not a manifestation of the student's disability and so you're going to move forward with expulsion. Ultimately, the IEP team has to decide what is an appropriate interim alternative educational setting that would still allow the student to receive FAPE. So even after the 10th day of removal, if you're going to expel a student, the student must still continue to receive FAPE, even if it's in a different setting. So you're going to have to identify another location for the student that would allow the student to participate in the general ed curriculum and to make progress toward their goals, even if it's in another setting. So there's still this obligation to provide the child FAPE, even if it's going to be somewhere else. So you're not going to be required necessarily to replicate all of the services and instruction that he would have been offered had he remained at the school, but it's going to need to meet the legal standard of still offering the student an appropriate program. For our charter schools, this may mean that when you expel a student that you could, in order to look for an interim alternative setting, you may be able to arrange for the student to attend your county's community day school or some other alternative program back in the local district, but sometimes charters are going to need to be a little more creative in finding those interim alternative educational settings for students during that expulsion period. So quickly we talked, I know we're running short on time, I know students, as we talked about, even if you are not yet eligible for special education, students who still have some protection under IDEA. So a student who's not identified as a special education student may assert IDEA protections if the LEA had knowledge that the student is disabled before the incident occurred. So schools will be deemed to have knowledge if the parent expressed written concern to supervisors or teachers that the student needs special education, if the parent has requested a special education evaluation. So if you are in the process of that assessment and then an incident occurs, you have to treat them just like you would any other student with disabilities and go through the manifestation determination process. The other one here is if the teacher or other school personnel have expressed specific concerns about a pattern of behavior directly to the special education director or to other supervisory personnel. So this really requires our staff who are our eyes and ears out there, that if other school personnel or if parents are expressing concerns about patterns of behavior, that could trigger us to essentially have knowledge that this might be a student with a disability, and we have to engage in the manifestation determination process. That pattern of behavior doesn't necessarily implicate disciplinary issues. So, for example, a child may exhibit severe forms of autism such that the child doesn't speak or engage at all, but doesn't act out or violate school rules. So a teacher may recognize these issues and communicate that fact to an administrator without identifying any disciplinary problems. So again, that is still a pattern of behavior that could trigger that basis of knowledge that a student is a student with a disability. This could even happen if communications are happening between a teacher and an administrator at a 504 meeting or at a parent-teacher conference. So if we are, again, we're hearing about disability-related concerns and patterns of behavior type of concerns, this could trigger that basis of knowledge requirement. The caveat to that is that an LEA is not going to be deemed to have knowledge if the LEA has already assessed the student and the student did not qualify for special education, or if the student was referred for a special education evaluation but the parents refused the evaluation or refused the services. So in either of those circumstances, you're not going to be deemed to have knowledge and have to go through the disciplinary safeguards. If a parent, and we get this, this does come up quite often, if a parent requests a special education evaluation at the time of the disciplinary action where the LEA did not have a basis of knowledge. So this is a situation where there's a conduct has occurred, maybe the student is up for expulsion, and then you get a request for an evaluation. So in those circumstances, LEAs are required to do an expedited special education evaluation. So the law doesn't say necessarily what an expedited evaluation means, but we know that generally the timelines for conducting evaluations are 60 days. So we know it needs to be something less than 60 days. I think the general rule of thumb is for these expedited evaluations when there's a disciplinary matter pending, 30 days is kind of the general rule of thumb in trying to expedite that evaluation process. What happens then is that you kind of have these parallel tracks where you've got the assessment going on. You're not sure yet if the student is going to be eligible for special education, but you also have certain timelines that you need to meet for the expulsion process. So schools may stop the disciplinary proceeding while we wait for the results of the evaluation and an IEP meeting to determine whether or not the student's eligible, but you're not required to stop the disciplinary proceeding. The risk there really, if you continue with the expulsion process while the special education side of the process is still pending, is that if you move forward with the expulsion and then later it's found out that the student actually did qualify for special education and, oh, by the way, it was a manifestation of the disability, you'd have to go back and undo the expulsion. So, you know, you have to think about kind of the pros and cons as you're dealing with kind of those two separate timelines of the special education process and the evaluation and the expulsion proceeding. And then once you've done the assessment, you would hold the IEP team meeting just like you would any other IEP team and determine whether the student's eligible. If they are eligible, you go ahead and you know, put together the IEP and offer services. During this time, though, the student will remain in the placement determined by the LEA. So whatever that placement is, whether that means the student is suspended pending expulsion, that's where the student stays until you finish the special education assessment process. If the student's eligible, you go through the IEP process, provide services. Of course, you could still continue with the discipline. If not eligible, the parent may request a due process hearing regarding eligibility, and similarly, you could continue with the discipline. Okay, well, I covered a lot of information there. Are there any questions before we adjourn? I really appreciate the questions that came through during the course of the presentation, but if there's any other questions, I'm happy to answer those now. Okay, well, it looks like we don't have any questions coming through, so, oh, yes, there is. There's one. I had to wait for some typing.
People who are asking about accessing the PowerPoint afterwards, we have been recording this, and we will post it on our website in the next couple of days, and I'll send an email out to everyone who attended, letting them know when that's accomplished.
Great. Thank you, Drew, so much. Thank you very much for participating. Oh, we got one more question. Okay.
Who runs the MDT? School psych? What if the psych is also the student's counselor?
That is a good question. You know, I would say there's not a perfect answer to that about who would run it. I think you have to identify whoever on your team is the most qualified to facilitate a meeting like that and really knows what all of the requirements are of the actual documentation process. So it could be the case manager, it could be the school psychologist. I've seen it done both ways, so I don't think there's a right or wrong answer there. It just should be a person who really makes sure to keep the team on track and make sure that all of the information is being considered and documented appropriately. So I think that's really up to you in terms of who would lead that, as long as you've got the appropriate people there to participate. Okay, well with that, of course, if you think of any other burning questions, I'm always available. I have my contact information here. If you'd like to reach out, of course, if you think of questions later on, I'm happy to answer those for you. So thank you all very much for your time this afternoon, and we will see you at the next webinar.